Article 19 of the Indian Constitution. Detailed analysis. Article 19 is one of the most significant provisions in the Indian Constitution, as it guarantees essential fundamental rights related to freedom. It ensures that Indian citizens enjoy various freedoms, while also allowing the state to impose reasonable restrictions for maintaining public order, security, and sovereignty. 1. Provisions of Article 19. Initially, Article 19(1) guaranteed 7 fundamental freedoms. However, after the 44th Constitutional Amendment Act, 1978, the right to property, Article 19(1)(a)(f), was removed and moved to Article 300(a). Now, Article 19(1) provides 6 fundamental freedoms. 1. Freedom of speech and expression, Article 19(1)(a). 2. Freedom to assemble peacefully, Article 19(1)(b)(3). Freedom to form associations or unions, Article 19(1)(c). 4. Freedom to move freely throughout India, Article 19(1)(d). 5. Freedom to reside and settle anywhere in India, Article 19(1)(e). 6. Freedom to practice any profession or to carry on any occupation, trade, or business, Article 19(1)(g). However, these rights are not absolute and are subject to reasonable restrictions under Article 19(2) to 19(6). 2. Reasonable restrictions on Article 19. The Constitution allows the state to impose reasonable restrictions in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offense. These restrictions ensure that individual freedoms do not disrupt public harmony or national security. 3. Prominent case laws on Article 19(1). Romesh Thapar versus State of Madras, 1950. The Supreme Court struck down a ban on a newspaper, stating that freedom of the press is a part of freedom of speech and expression, Article 19(1)(a). 2. Bennett Coleman and Company versus Union of India, 1973. The court held that restrictions on newspaper page limits violated freedom of speech and expression. 3. Shreya Singhal versus Union of India, 2015. Section 66A of the IT Act, which criminalized offensive online speech, was struck down as it violated freedom of speech under Article 19, 1 of 4th Indian Express Newspapers versus Union of India, 1985. Tax on newspapers was challenged as a restriction on press freedom. The court ruled in favor of freedom of expression. Aindamaka K. Gopalan v. State of Madras, 1950. This case initially separated Article 19 and Article 21, stating that personal liberty under Article 21 does not include Article 19 freedoms. However, this view was later overruled. 6th Maneka Gandhi versus Union of India, 1978. This case linked Article 19 with Article 21, stating that procedure established by law must be fair, just, and reasonable. 4th. Role of Article 19 in the modern world first. Social media and freedom of expression. Platforms like Twitter, Facebook, and Instagram are modern spaces for speech and expression. However, governments regulate content to prevent hate speech, fake news, and national security threats. 2. Right to protest. Protests like Shaheen Bagh, CAA protests, and farmers' protests involved Article 19(1)(b), right to assemble peacefully. The government can impose restrictions under Article 19(3) for public order. 3. Digital freedom and internet shutdowns. Kashmir Internet Shutdown Case, Anuradha Bhasan v. Union of India, 2020, stated that the right to access the Internet is part of freedom of expression. Fourth, regulation of OTT platforms. Government policies on Netflix, Amazon Prime, and YouTube balance freedom of expression with morality and public order. 5. Corporate and economic rights. Article 19(1)(g) protects businesses but is subject to public interest regulations like minimum wages, environmental protection, etc. 5. Relationship between Article 19 and Article 21. Article 21 of the Constitution states, "No person shall be deprived of his life or personal liberty except according to procedure established by law." Link between Article 19 and Article 21. Post-Maneka Gandhi case, 1978. The Supreme Court ruled that fundamental rights must be read together. Freedom of speech, Article 19(1)(a), is meaningless without the right to life and personal liberty, Article 21. Right to privacy, Puttaswamy case, 2017, was recognized under Article 21, impacting freedom of speech and data protection.
Sixth relation to the Ranveer Allahbadia case. Who is Ranveer Allahbadia? He is a YouTuber, influencer, and entrepreneur known for motivational content and entrepreneurship insights. Controversies surrounding him. There have been allegations of misinformation, controversial opinions, and content regulation issues. His case brings up debates about freedom of expression, Article 19(1)(a), versus reasonable restrictions, Article 19(2). How Article 19 and 21 apply in his case. Article 19.1.a, freedom of speech. Or, as a content creator, he has the right to express opinions. Or, however, platforms and governments can regulate misinformation or offensive speech. Article 19.1(g), right to business or his business through YouTube and podcasts is protected under Article 19.1(g). Oh, but platform guidelines and regulations act as restrictions. Article 21, right to privacy and reputation. Oh, defamation cases or online hate campaigns against him could violate his right to privacy and dignity under Article 21. 4. Platform restrictions, private censorship. Oh, YouTube and Instagram, as private entities, can demonetize or remove content, raising concerns about private censorship versus fundamental rights. 7. Conclusion. Article 19 guarantees essential freedoms in a democracy, but comes with reasonable restrictions. Article 21 ensures life and personal liberty, which complements Article 19 by making rights meaningful and justiciable. In the modern digital world, issues like content moderation, misinformation, and censorship challenge how Article 19 and 21 apply. The Ranveer Allahbadia case highlights tensions between free speech, business rights, and platform regulations, making it a contemporary test case for digital freedom in India.